Welcome, friends, to the June installment of the Slingshot. Today's special guest is Steve Salop, Professor Emeritus at Georgetown Law School, who teaches, among other things, antitrust law. Now, Steve is a prolific writer, publishing papers at a dizzying pace while keeping several working papers in the pipeline. Steve is also a bit of an antitrust reformer, having signed the joint letter to the Judiciary Committee in April 2020, calling for Congress to update the antitrust laws to, among other things, and I quote, alter substantive legal standards in the allocation of pleading, production, and proof burdens to reduce barriers to demonstrating meritorious cases, end quote. Steve also publicly supported, along with Fiona Scott Morton, the American Innovation and Choice Online Act, a bill that would have regulated self-preferencing by dominant platforms outside of antitrust law. These are the kind of troublemakers we like to have on the show. Welcome to the Slingshot, Steve.
Thanks, Hal. It's a pleasure to be here.
Great. And joining me today on the panel to ask Steve questions is Darren Bush, professor at the University of Houston's Law School, and Theodosia Stavroulaki, assistant professor at Gonzaga Law, teaching antitrust and public health law. Hey, Darren. Hey, Theodosia. And I hope I did your name justice there. How's everything?
Oh, great. You pronounced my name properly, Hal.
Thanks.
Happy to be here with you today.
Thanks so much for joining. Now, today's show will be divided into three segments. In the first, I'll ask Steve questions about some current developments in antitrust. Then Darren will ask Steve about his new article titled Countervailing Exploitative Pricing with Joint Negotiating Entities. And then Theodosia will ask Steve about his other new article titled Antitrust Worker Protections. The Rule of Reason Does Not Allow Counting of Out-of-Market Benefits, published in the University of Chicago Law Review. Not too shabby. Of course, this is a free-for-all, so Darren and Theodosia should feel free to jump into my segment, and if I'm inspired, I'll jump into yours. So let's begin. So Steve, first question, based on my review of your writings, I think you are the position that as a result of how U.S. courts have interpreted antitrust law, and the Supreme Court's interpretation in particular, there is vast under-enforcement of antitrust in the United States, particularly with respect to single firm monopolization cases. Now, the question that I want to put to you is how to fix it. The House Majority Report advocated that Congress nullify several Supreme Court decisions, including Trinco and American Express. And a portion of Senator Klobuchar's new bill titled Calera would do just that. Would you be willing to support a skinny version of a bill that only nullified certain Supreme Court decisions? And if not, why not? And if so, which decisions stand in the way of effective enforcement of single firm monopolization cases would you like to see nullified by Congress, and why?
Okay, well, I'm not sure what to do with the word skinny here, but I would definitely like to get rid of American Express and Trinco. But I mean, I'd like to go beyond single firm monopoly. I'd like to do something about merger law to return it closer to Philadelphia National Bank, and also a more interventionist legal standard for agreements in price fixing cases. So let me start with American Express. In my article, which is published in the Antitrust Law Journal with Daniel Francis and some others, and like all the articles I'm going to mention, posted on SSRN, we say that this is one of the worst opinions in the last 100 years, which is really saying something because there have been some doozies. So let me go through the reasons. And I've actually got a long list here. I may need to consult with my notes. The list is so long. So let me start with market power. The court said you need to prove market power. And bizarrely, the court rejected the use of direct evidence for proving market power. It said that in vertical cases, you need to prove market power by first defining the market and then measuring market share. And this is just so wrong. It's a matter of economics. Market power is defined in terms of price cost margin, not in terms of high market share. But more importantly, what we've learned in the last 30 years is the direct evidence derived from conduct, from natural experiments, if you will, is generally considered more reliable than using the imperfect tools of market definition and market shares. In other words, direct evidence is more powerful than circumstantial evidence. So, for example, there might be evidence that the firm increased price after adopting the conduct. So that was the first big mistake that they made in the opinion. And to give you a sense of how bad it is and how bad the opinion is, the support in the footnote, the court cites to a Frank Easterbrook article for the proposition that you need to gauge market power in vertical cases. But what it doesn't say is that on the same page of the Easterbrook article, he embraced the use of direct evidence of market power. He doesn't say you need to show high market share. And if you'd ask Frank, he'd say direct evidence is better than circumstantial evidence. That's the first problem. Second, they didn't define the market correctly. They said this is a two-sided transaction platform market that involves complementary products. But normally markets are defined in terms of substitutes, not in terms of complements. Now, I think they did that because they thought, they deviated, if I want to give them credit, they deviated because they thought they wanted to analyze competitive effects, and you need to look at both sides. But needing to look at both sides doesn't mean you need to define a single market. You could define two sides and make the point that they interact. Third, the court pretended that Visa and MasterCard would prevent American Express from exercising market power. But the opinion ignored the fact that Visa and MasterCard also had their own anti-steering rules. So this, if anything, exacerbated the effect of Amex's rules, not decreased it. Okay. Next, I'm not done yet. Fourth, and really my favorite, because it's the biggest mistake of all, the court said that the anti-steering rules led to increased output, which they said is a good thing. But they ignored the fact that given the structure of the rule, the anti-steering rules would lead to excessive credit card usage, not a reduction in output. In a sense, it would lead to output above the competitive level, not a contraction. The reason why is that it creates a prisoner's dilemma. That is to say, if you go through the steps, the networks charge a high interchange fee to merchants, which lead the merchants to charge a high merchandise price because they weren't allowed to surcharge users. The only way they could begin to recover the higher cost is by raising their merchandise prices. So consumers, given that, would rationally not take into account the fact that if they use the cards more often, it's going to lead to higher merchandise prices. Instead, they're going to be driven by the small benefits they get from using their credit card. So standard economics, they ignored the externality, and so they overuse the card, just like too much pollution. So this has also got an important, not only is this kind of the theory of the case, but the implication is that the increased card usage, that is increased card output, doesn't mean that the rules are pro-competitive. Quite the opposite. Okay. Of course, the court wasn't done. They made another embarrassing mistake. They said credit card transactions rose over the past decade. That was how they measured output, as if the rules caused the increase in the last decade. But of course, there were lots of other factors that led to increased usage. So bad opinion, already caused damage, as we saw from Sabre Fairlogics. Courts have to get rid of it. Maybe it can be marginalized by the courts. Maybe it can be ignored. Dogger was essentially ignored, but maybe that's something that Congress needs to deal with. Next, Trinco. Okay, go ahead.
Excellent. No, that's what I was going to ask you, is you could just comment on Trinco, because I feel like American Express, there might actually be a consensus forming in antitrust community among all stripes that American Express was wrong. I don't hear many defenders of that, but Trinco, I'd like you to weigh in on.
You should read all the amicus briefs on American Express in favor of American Express.
Okay.
Don't speak too soon.
Okay.
Maybe people are just embarrassed to talk at this point. Okay, anyway, Trinco is problematic because it limits refusal to deal allegations by demanding a previous voluntary course of dealing. So if you think about that from an evidence point of view, they think, well, that's a way to demonstrate anti-competitive intent. But there's other ways. I mean, for example, suppose you discriminate against competitors versus non-competitors. That also suggests anti-competitive intent. So that's one problem. But more generally, this is the case where the court really overemphasized really false positives while ignoring false negatives. For example, it ignored the fact that it's competition that spurs innovation. They treated it as the opposite. They were worried that if you created another competitor by letting it buy inputs from the dominant firm, that would reduce competition. But the whole point is that firm couldn't enter at both levels because the upstream firm had an essential input. And so if you want to get competition, if you want to get more innovation, you have to have competition. The court also thought that you couldn't set a price, but there are ways to set a reasonable benchmark price. And I would cite you to my antitrust law journal called the Protected Profits Benchmark on how to set the price. So I think Trinco's got to go more generally. And you mentioned self-preferencing. I'd like to see the US adopt something like the European Commission's abuse of dominance statute that can be applied to essential facilities cases.
And is the clean, so Darren, go ahead. You're about to jump in?
Yeah. So Scalia in Trinco, the case that should never have been brought, as Stephen points out in the concurrence, that there's a standing issue in there. But he talks about the prior course of dealing in Aspen Ski, which is true, there was, but also an Otter Tail. What's the prior course of dealing in Otter Tail that he's relying upon? There was no prior course of dealing between those two parties in that particular wheeling transaction.
Right. And in Aspen, not only that, not only did they talk about the prior course of dealing, but they also talked about the fact that Ski-Co had blanket licenses, had multi-mountain licenses at multiple other resorts.
Right.
And of course, in terms of the refusal to deal, it's not as if they weren't selling daily lift tickets. They were selling daily lift tickets in bulk to promoters, to tour operators, but they wouldn't sell them in bulk to Highlands.
So just to kind of close
I just need to comment. The standing, I understand what Stephen said, but he was wrong on standing. Not allowing, it's basically an umbrella damages sort of idea. If you're dealing with the dominant firm, if you're dealing, with the excluded rival, as a consumer, you're still harmed by the conduct. There's no reason to make the only potential plaintiff be the rival. Better to have consumers if they can do it.
Right.
And they've got different injury than the rival.
I just want to put a bow on this one and because I feel like there may have been some confusion over my word skinny. That's something I aspire to be on my jogs. But I also wonder, Steve, if there was a bill in Congress that, I know that Calera does a bunch of other things besides nullify certain Supreme Court case law. If there were a skinny bill that only did this, right? Is that something that you could get behind and maybe get some of your friends in the antitrust community to get behind as well?
You mean take half a loaf and rather than hold out for the whole loaf? Sure.
Yeah, I remember a tweet exchange between you and Herb Hovenkamp where Herb was picking on other alleged infirmities in the bill that had nothing to do with nullifying these cases. And I was just wondering if we could just set that to the side and just focus on the nullification of a handful of cases. Could we make some progress? That's what I meant by the skinny bill.
Beats me. I don't lobby.
All right. So let's shift over to price fixing, because I know you want to talk about things besides monopolization. But I think there's another soft spot in the law here as well, particularly when smoking gun evidence of an agreement is lacking. So we've seen district courts in these types of cases implicitly adopt the notion that oligopolistic interdependence is just as likely to achieve prices inflated over competitive levels as agreement. And so merely alleging or putting forward evidence of parallel pricing, excess capacity, and artificially inflated prices is insufficient in their view to prove agreement under Section 1. My question for you is, why should we assume that it is just as easy to maintain artificially inflated prices tacitly than through agreement? And I've advocated, I'm not going to suggest you have to too, although it would be nice if you did, but that Congress flip the presumption, effectively reversing Twombly. In particular, Section 1 of the Sherman Act could be amended such that evidence of parallel pricing accommodated by evidence of interfirm communication of competitively sensitive information would be presumptively in violation of Section 1, with the burden of proof shifting to defendants to prove otherwise. Now, are you open to Congress resetting the standards for proving a conspiracy in that way? And if not in that particular way, my feelings won't be hurt. How would you do it? Or are you happy with the status quo?
Okay, well, look, price fixing is the so-called supreme evil, and making it hard to prove an agreement makes no sense for that reason. But let me break this down. First of all, the problem is Monsanto, not Twombly. Twombly is about motions to dismiss, and plaintiffs routinely are able to get past Twombly. The more serious doctrine is Monsanto, which where more evidence is required to avoid summary judgment or win on the merits. So it's really Monsanto. And if people are interested, kind of any antitrust students are listening, Posner's got two opinions in the text messaging case, one on the motion to dismiss, and then one on the merits, and they go together, where he shows that you need more evidence to win on the merits than you do to get past a motion to dismiss. And it's in my side here is, if you look at the Andy Gavel's case book, he has both opinions in there. So under Monsanto, when there's no direct evidence of an agreement, it's necessary to show conduct that's inconsistent with independent self-interest. And courts have placed an overly high burden here. So parallel pricing could be in your independent self-interest rather than coming from an agreement. And that's been the law. Hal, that's been the law for 60 years. That goes back to Theater Enterprises, which said concerns about parallel pricing have not written agreement out of the Sherman Act. So that's not a recent issue. That's a long-standing issue. But if you've got, so parallel pricing is not enough. Parallel pricing plus tight oligopoly structures not enough. You still need something more. Normally, what you need more is communications.
Yeah.
And so if your rule is you got to prove communications, well, then that's already in the law. And it's not a matter of shifting the presumption. That's evidence to carry the merits. Where the cases have gone wrong is they are taking communication evidence and painting lipstick on a pig. And that's what you need to get over. And boy, my case in point when I was teaching was the Blomkest case, where kind of all the errors in Blomkest, the one that comes to mind here is the one firm called the other firm to say, yes, we charged a low price to that one customer, but it was a mistake. And the court said, oh, well, see, that's not a way to collude because they did it after the fact, not before. But the court totally missed the point that the apology was a way to say, hey, I really didn't mean to defect from the agreement. You can trust me in the future. So that's the kind of error that's been getting made. Now, in terms of changing the law, one thing that's interesting about it is that the Monsanto standard got set in the context of an intra-brand vertical restraints case. The court was set, it was under Sylvania before Dr. Miles got reversed. So the court said, we need to make it really hard to prove an agreement in this case in order to protect the Sylvania rule of reason against the Dr. Miles per se rule. But then Monsanto got extended from intra-brand vertical restraints to horizontal price fixing cases. It's almost like that was an unintended side effect. And so if you would just cut back Monsanto, maybe that would be enough.
And how would that cutting back occur? Are you talking about Congress passing a law?
Well, there's always two ways to do things. You can go to Congress, or the Supreme Court could realize the error of its ways.
Got it. All right.
But
Well, I
somebody
think
like Posner started by saying parallel pricing was enough. And then he said, no, that's not enough. And sort of towards the end, he was coming back to his earlier position.
got it. All right. Well, I think that we've probably used up the time for my segments. I'm going to pass the baton over to Darren. If we have more time at the end, which I'm hoping, maybe I'll get another question in or two. Darren, why don't you take a stab?
All right. Well, my question is on your paper on joint negotiating entities, or JNEs. Just kind of walk us through what the basic premise of the paper is. What you're thinking here in terms of sort of countervailing power, or to monopoly or monopsony power.
Okay, well, that's great. I'd like to do that. Let me use the example of monopsony. So suppose you have a dominating buyer who's purchasing from a lot of small input suppliers. Now, that firm has monopsony power. Now, just footnote, I'm using the term monopsony here broadly. I want to include both classical monopsony power, that is restricting output in order to pay a low input price, but I also want to include in it dominant Nash bargaining power. So you can frame this in the context of a bargaining model as well as classical monopsony. Indeed, in a bargaining model, if the buyer has all the bargaining power in a Nash bargaining model, it will set the classical monopsony, it'll negotiate the classical monopsony price. So I'm using the terms that way. So under my proposal, various groups of small suppliers could form these joint negotiation entities, or JNEs, and each JNE would have moderate countervailing bargaining power. And the idea is that the economics shows that a JNE with only moderate bargaining power, and we'll talk about what moderate means in a minute, it'll not only lead to a higher input price, benefiting the input suppliers, but it will also lead to increased input purchases. That is, it doesn't cartelize, it doesn't move back on the demand curve. Instead, it's going to move purchases along the upward sloping supply curve. So you get more input purchases. And as a result of the greater input purchases, the monopsonist will now produce more output downstream. And when it produces more output downstream, that'll lead to lower downstream prices. So not only will the small input suppliers gain a higher input price, but downstream consumers will get lower downstream prices. So no conflict between downstream consumers and input suppliers. So my idea is that this should satisfy both the post-Chicagoans and the anti-monopolists, because both gain. Right? But the key is that the JNE can't be so large that it gets dominant bargaining power itself. If it did that, then it could cartelize the market, move back along the demand curve, and have lower input purchases and higher downstream prices.
So each year that there's these, I mean, I assume these prices are negotiated and repeat in a kind of a repeat game, correct?
Yeah.
So do antitrust enforcers have to step in and continuously, monitor what the balance is between the two types of parties here, the JNE and the monopsonist?
Yes. I mean, if the buyer side becomes competitive, for example, then the JNE would need to be disbanded.
Okay.
And, I think, I mean, that calls for some ongoing monitoring by someone. And, I think the dominating buyers would have an incentive to report changes in structure that would allow them to do that.
Okay. So let me quote something from your piece and see what you think about this. I mean, I know what
this is like a deposition.
Yeah. You say one flaw is I want to pose this hypothetical. You tell me if it's plausible. You say one flaw in this criticism is that such wished for perfection may be highly unlikely. JNE formation is permitted only after the powerful firms have already exercised substantial power for a durable period, say 5 to 7 years. So I presume there's no sign of entry in the midst. If entry has not already occurred, that suggests the existence of significant entry barriers, which may continue to deter entry for a longer period. So
I said that. Yes, I said that.
All right. Suppose we are on year 6 of a market where a firm wields monopsony power. In year 6, a credible entrant seeks to challenge where there's been no prior entry before. And the monopsonist then requests the JNE to deter entry. Is that plausible or no?
Not plausible. And the easy answer, the entrant's not a dominating buyer. So the J&E wouldn't be permitted to collectively negotiate with the entrant.
Right, but could the monopsonist, who is the dominant buyer, use the JNE to deter entry?
Well, what do you mean? How would it do that? It would
Each
do
price
that
is-
by offering a lower, it would do that by offering a higher price?
Yes, it would keep it. In other words, that would deter. It would the higher input price would deter the entry in the output market.
Well, no, it deters entry into the J&E the members of the J&E can still sell to the entrant. So the dominant buyer is just going to be paying a higher price. The entrant, meanwhile, can go to each individual seller, negotiate a lower price, and it can compete.
Okay, and the JNE members will have an incentive to do that.
Well, each individual J&E member, sure.
Okay. See, it is like a deposition, you know. You get two
Except-
economists in a
except
room.
usually the questioning attorney doesn't smile and say, "Oh yeah, that's a good answer."
Well, all right, that's fair too. So you are you? It's possible these could go on for years and years, right? I mean, it could be a temporary or a permanent solution depending on the durability of the monopsony power.
Yeah, that's the idea.
If that's the case, why not?
The idea is that right now, suppose you have a durable monopsonist, and right now, the antitrust laws say, bless your soul, you can exercise that monopsony power. That's fine. Our antitrust laws can't do anything about that, and that's a problem. And so the question is, should we do anything about that problem? Some people say you should break up the monopsonist. Some people say you should regulate the monopolist prices. So I'm coming up with a third thing that you can do, which is rather than regulate, let these J&Es form countervailing power. It's another possible, if you will, remedy to the monopsony problem.
Okay. I suppose my hypothetical kind of suggests that you're suggesting a model where the J&E members will coordinate with the in order to countervail the power of the monopsonists, but you still think they'll compete if there is an entrant in the output market. And I'm having trouble reconciling that. Maybe I'm just too suspicious in my view of the world.
Suppose there's 20 suppliers in the J&E. And so they're getting a good deal from the monopsonist. But then each of the 20 would still have an incentive to individually sell to the entrant, whether or not that single supplier with less than 5% of the market, because there could be two J&Es selling to the monopsonist, he's going to sell a little more. Whether he sells a little more to the entrant at a low price is not going to determine whether the entrant succeeds or not. That is to say, he's got an incentive to defect from the J&E. And in my case, the J&E is not a cartel. You're implicitly assuming a single J&E has got cartel power. My J&E only has moderate bargaining power. So I think there's a big incentive for the individuals to sell to the entrant.
Yeah, you caught my assumption. I was throwing in there as a fastball. Why not? Doesn't this seem like why not just regulate? It seems like this is a very long and protracted way of indirectly regulating.
Well, because I think this is regulation light. All you need to regulate here, all you need to look at here is structure, and you don't need to set a price.
Okay.
So you can do something, suppose if you want to think about this in market definition terms, suppose the monopsonist has got, the so-called monopsonist has got 70% of the sales, and he's buying from sellers that have 5% each. Well, that looks like a situation where you ought to allow a J&E. Now, I'm not going to allow all the suppliers to get together, just enough to have moderate bargaining power. So maybe there would be 3 J&Es negotiating with this guy with 70%. Each J&E would account for a third of his purchases, rough, to begin with. So that doesn't seem like such tough kind of regulation to me. A lot harder for somebody to sit down and say, oh, what I think the price should be is $17.44.
Yeah, that's fair. All right. Well, I have no further questions at this time.
Before we pass the baton to Theodosia, and I'll ask you if it's okay with me, because I just can't help myself when we're talking about J&Es, joint. If I could inject something about the newspaper bill, but if you don't want to go there, we can leave that. That was an example.
I can talk a bit about the newspaper deal. I mean, it is in the spirit of what I'm proposing. It's interesting because they allow a coalition of the whole. All the newspapers, except the very largest, like the New York Times, can get together. So there's more of a potential for what you might call cartelization. Secondly, they allowed the broadcasters in, who don't even make any content, right? They take content themselves. But what somebody told me was, well, that's how you make sausage. If you want to get a bill passed, you need to have compromises. So that's one issue. And what I think's going on there, and it's kind of interesting, is one of the criticisms of the J&Es, one of the defenses of the monopsonist is that, oh, if you take away their monopsony profits, they won't innovate as much. But here in the newspaper case, the implicit assumption that the Congress is making is that we'd rather have more investment by the newspapers in content than we would like to have investment in digital platforms by Google. And well, that makes a certain amount of sense to me, that the innovation on one side is worth more than the innovation on the other side. And I talk about that issue more generally in the context of my paper. The other interesting thing I saw that I hadn't thought about so much in my J&E paper is, in my paper, the monopsonist does not have a duty to negotiate. He could just say, screw you. Because just like, a buyer and a seller in a regular market, they can refuse to deal with each other. In the newspaper case, there is a duty to deal by the platform. And if they fail to reach a deal, there's an arbitration backup.
Yeah.
So I don't have that in my proposal. And it could be added, but I don't have it now.
Yeah, and I should just disclose that I've got a client in the mix for the News Media Alliance, and I was one of the drafters of that bill. But we thought we needed the backup because
so
we thought
the problem.
the power imbalance was so large that Google or Facebook could just walk away and decide not to carry news. So that's why we had the backstop of the arbitration. But anyway, I think we probably should pass the baton. Thanks for weighing in on that one, though. I'm going to take that as a ringing endorsement of the bill. Theodosia, before Steve can say anything, why don't you take the baton from me and we'll head on to your segment.
So I had the opportunity to read Steve's article, Antitrust Worker Protection, which I highly enjoyed. But before we get to your article, I have a more basic question. Has antitrust failed workers? And if so, why?
Okay, well, before I turn to that, I just want to make it clear for the record, that was not a ringing endorsement. No.
Okay.
Okay, so yeah, I think antitrust has failed workers. Several reasons. I mean, until recently, they've tended to treat labor markets as highly competitive with no monopsony problems. Either classical monopsony or dominant bargaining power. If anything, when I was in graduate school and coming out, unions were seen as the bad guys, that they were acting as cartels, or at best, they were providing the countervailing power. And then antitrust also took on the idea that where there were welfare conflicts between workers and downstream consumers, the impact on downstream consumers was given priority. And so that's the sense in which antitrust has failed.
And some people say that suppressed wages and income inequality are not really antitrust problems, and they're more labor law problems. And my question is, how would you respond to this argument?
Well, I mean, there's the inequality problem we have these days. There are a lot of reasons. I mean, it's not either or. I mean, changes in labor law have been significant. Globalization has been significant. Technological change has been significant. But that doesn't mean there's no antitrust problem. I mean, anti-competitive conduct that suppresses wages is a valid antitrust concern. And second, lax antitrust enforcement that creates market power downstream typically also harms the distribution of income. I mean, stockholders and top executives who benefit from market power are richer than the typical consumers. We've got counterexamples. I mean, the one I teach is the boat builder, the yacht builder that's owned by the widows and orphans of former workers. So there, maybe allowing them to monopolize would improve the distribution of income, but that's not the typical case.
So in your article, you discussed thoroughly the Supreme Court's ruling in Philadelphia National Bank, where the court said that any out-of-market effects cannot be considered in the context of a merger analysis. And in your paper, you argue that the Philadelphia National Bank approach to mergers should also apply to all buyer-side restraints analyzed under the Sherman Act. For instance, if a competitive restraint harms workers but benefits downstream purchasers, such benefits may not be considered in the context of the recent legal analysis. Could you elaborate on this point?
Yeah, that's the key point of our article, in fact, and you've stated it very well. I'd say it's not just that we think it should be, but we think a proper interpretation of the ancillary restraints doctrine would compel that answer, that it's not just policy, it's also law. That ancillary restraints has been, that doctrine has been distorted over time. So yes, harms to workers cannot be justified by the benefits to downstream consumers, but they are. I mean, if you take the McDonald's franchise case, McDonald's has an agreement with their franchisees that the franchisees cannot poach workers from one another. Now, in the case, and it's a case that's now on appeal at the Seventh Circuit, the district court acknowledged the anti-competitive effects of the agreement. But the court justified the conduct by saying it would lead to lower hamburger prices for downstream consumers. So they said downstream consumers are privileged over the workers who are harmed. And we think that's the wrong approach.
Somebody could argue that this proposal is not necessarily in line with the recent ruling in NCAA versus Alston. And my question is, how would you respond to this argument?
Okay, well, Alston is a case where the NCAA had an agreement that capped the payments to the athletes for educational expenses. And so in a sense, the athletes' wages are held down to benefit the fans. Now, Alston was a special and unusual case. The parties had reached an agreement. Okay, so the plaintiff and the NCAA had reached an agreement on the educational expenses, but they both appealed. So the out-of-market balancing issue was a little different because they had this agreement. Where the rubber is going to hit the road is in the next case involving restrictions on non-educational expenses, including what they call NIL payments, name, likeness, and images. And on that case, I don't see how the courts are going to ignore the harm to the athletes. What the claim comes down to, the balancing claim comes down to is, gee, fans get a lot of pleasure from knowing that the athletes are being exploited. Well, that doesn't seem like a cognizable efficiency to me. And I think my side has at least one vote. I mean, Justice Kavanaugh, in Alston, he ends his opinion by saying in his concurrence, and I'm going to read this, college football traditions alone cannot justify the NCAA's decision to build a massive money-raising enterprise on the backs of student athletes who are not fairly compensated. The college football tradition is the tradition that we like watching slave labor. So I just don't think it works. So I think the next case, the plaintiffs are going to win. But, we'll see. Now, how should it come out? If the courts want a balance, they're going to run into what Rebecca Allensworth calls the incommensurability issue. She's got a very nice article on this. Now, we often think of incommensurability as kind of the conduct raises prices, but also raises quality, or raises safety, but also raises prices. But, as economists, interpersonal comparisons are inherently incommensurable, even if they both involve money. And Justice Scalia put this perfectly in an earlier case. He said, the balancing basically involves whether a particular line is longer than a particular rock is heavier. It's two things that are incommensurable. And Gorsuch has reflected that line. And, so I think it's going to be hard for them to buy into balancing. In fact, at the conference in Chicago in April, I asked Diane Wood, Judge Wood, and Judge Easterbrook about out-of-market balancing, and they both said that's really hard to do. Courts don't like to do that. Okay, so it gives me some confidence. Now, the other point is in American Express, they defined this single two-sided platform market. So why did they do that? Well, who knows? But one thing they gained by defining a single two-sided platform market rather than two markets, each single-sided, is they could say the harms to the merchants and the benefit to the Amex cardholders was all within the same market. They didn't need to engage in multi-market balancing. So I think that was part of what they had in mind. Again, it speaks to the fact that if you could get the courts to define this post-Alston case as having two markets, they will come out against the NCAA.
In your article, you also mentioned that the court may actually disagree with your proposed bar on balancing in market harms against out-of-market benefits. And if this is the case, you also argue that the court should place a high burden of proof on the defendant to show that the benefits of the restraint disproportionately exceed the harms. And in the proposed legal test, is the proposed legal test in line with the way the courts apply the rule of reason thus far? Would your proposal actually require different application of the rule of reason?
Well, look, the rule of reason is really broad, right? Some people say the rule of reason encompasses the per se rule. It certainly encompasses the quick look. So I wouldn't say you need a new rule of reason, but just a different emphasis. And as you put it, what I want to do is raise the defendant's burden of proof on rebuttal. If you're going to balance, you should put a heavy burden on the defendant to show that despite the harm to users in one side of the market, the benefits to the others are way disproportionate.
Are there any situations, or have you thought of any situations where a non-compete agreement among employers may actually create some pro-competitive benefits in the labor market? And could you give us some examples?
Yeah, well, a good question. I mean, because what we're saying is that you can't say that harms to the workers are justified by benefits to consumers in another market, but you can say that the harms to the workers are justified by benefits to the workers. So if you go back and think about a case like Legion, the resale price maintenance case, the argument is that consumers are going to have to pay a higher price from the resale price maintenance, but those same consumers are going to get the benefit of higher quality, more promotion, more aftermarket services, more advertising, et cetera. So it's the consumers who pay the higher prices are also the same people that get the quality benefits. So how could the workers gain? So I think the simplest example would be where two firms have a research joint venture that use workers from both firms, and those workers have specialized knowledge. So each of the JV partners may be unwilling to enter into the JV if it fears that its partner will poach the workers. Now, those workers wouldn't get to participate in the JV. They wouldn't get the higher demand for their services absent the no poach. So that's the way that's a legitimate. It seems to me it could be legitimate. And in the Silicon Valley, the first of the modern no poach cases that actually began with the workers collaborating on R&D projects, but then it expanded. Then Steve Jobs called Eric Schmidt and said, "Hey, we should apply this to all the workers," and that's where they crossed the line.
Some scholars say that antitrust law should permit workers to collaborate in order to increase their bargaining power against powerful employers. And my question is, do you agree with this argument? And what are the main pros and cons of such policy option in your view?
Okay, well, that's basically the J&E proposal that I discussed with Darren, applied to workers. So monopsony employer with a J&E of workers, where the J&E would not have to be a union. It could be a voluntary association that doesn't meet all the NLRA rules for unionization. In fact, truth be told, that was the original impetus for my proposal with Darren. Doug Melamed and I have an article. It's posted on SSRN. It's coming out in the Antitrust Law Journal, in which we propose a worker exemption along the lines of what Darren and I talked about. And I actually think that the policy is the strongest with respect to workers. We've got lots of evidence, lots of empirical evidence of employer monopsony or dominating market power. Workers have switching costs. They have imperfect information. They've got limited savings that allow them to deal with a spell of unemployment. And so, I think there's a strong justification for the proposal there.
Can I jump in real quick to just ask a follow-up question to you? So you're right that workers are very vulnerable to layoffs and things of that sort. Does this suggest to you that when the new guidelines come out sometime in the next decade or so, that efficiencies should not be counted at all?
Well, firms hardly ever win on efficiencies. I think efficiencies were relevant in Sprint T-Mobile, but that's the only case the only case in court I can name where they seem to have gotten any traction.
But that's not true in terms of enforcement, because, for example, the airline industry, the out-of-market efficiencies.
First of all, let's go about in-market efficiencies first. No, out-of-market efficiencies should not count. That's easy. Okay, and again, I recommend Hemphill and Rose, which is a nice companion article for my Chicago article with Alexander. But even within market efficiencies, the agencies tend to be skeptical, and they should. And I would say not just in horizontal mergers, but also in vertical mergers. And on that, I would note, the FTC's recent decision in Illumina Grail, their discussion of efficiencies is pretty good. They, in fact, get Dennis Carlton to concede that he didn't do enough work on elimination of double marginalization.
Yeah, there was, and of course, there was another. I was going to make a snarky comment about JetBlue, but I'll pass. Hal, you're on mute.
Steve, do I have time for one more question for you? I don't know how we're doing.
I've got all day.
Okay, let me try this. This is my last one for you, I promise. It's on the topic of potential competition. And you penned a piece in Pro Market. You see how I'm using my platform to promote a rival, explaining how the court erred in the FTC's challenge of Facebook's acquisition of Supernatural by imposing an excessive evidentiary burden and disclosure. I was the FTC's expert in that case. Now, what would you do to better police mergers that threaten potential competition? Does Congress need to repeal some bad law there as well? Or what do we need? What do we need in this front?
Well, maybe the FTC picked the wrong witness, Hal.
Maybe so.
Okay.
I'll point out for the record, we did win on market definition, which was my mandate, but go ahead.
Half a loaf. That's a very small half a loaf.
I know. I was defending my honor. Go ahead.
Okay. Look, in that case, the district court interpreted the legal standard, the reasonable probability standard, as requiring evidence showing something more likely than not. Okay, so the plaintiff, the FTC, needed to show that it was not only that it was more likely than not that Facebook could have entered on its own, but much more, something north of more likely than not. And that standard's too high, in my view. It should be reasonable probability in a horizontal case normally is less than more likely than not. It's appreciable danger where all doubts are resolved against the merging parties. And I think that should be the case for potential entry cases as well. I've got this article called A Probability of a Probability, which is the longer article from the Pro Market. And in that, I've got a hypothetical in which there are three potential entrants, three and only three. And each one has got a 20% probability of entry. And then there's the question is, can the incumbent monopolist buy one or more of the entrants? Well, clearly he can buy one of them. That one of them only has a 20% probability of entry. So that's not going to disturb things very much. But if you actually work the probabilities, the probability that that at least one of the three would enter is only 49%. So under even the more likely than not standard, the monopolist could purchase all three of those entrants, which seems crazy to allow them to purchase all the potential entrants. And that's I think a nice solid example of why the standard needs to be more interventionist.
And how do we get there? Again, my last question for you. Is that a congressional intervention, a new law, or how do we do that?
Well, the very high standard on potential entry cases goes back for a really long time, goes back to 1980. The judge in the Facebook case relied on a 1980 Fifth Circuit decision. There was an FTC decision in the early 80s in which they said you need to have clear proof, very high standard, clear proof of entry by potential entrant. So the standard needs to be changed. That can be done by the courts waking up, or it can be done by Congress. Same as everything.
Got it. Well, I think that might do it for our time. I really appreciate it. I think it was a fascinating antitrust lesson, and I will encourage my students and all students of antitrust to give this a watch. Steve, we really appreciate you being here. Darren, Theodosia, thanks for joining, and have a great day.
Okay, thank you very much.
Thanks, Steve.
Really fun. Really fun. Thank you.
Thank you.